I'm Drew Stevenson, and this is a lecture for my administrative law class about the case Sierra Club v. Costle, a DC Circuit Court of Opinions case from 1981. This is a case that's pretty famous and is in a lot of the administrative law case books. And what we're talking about here are ex parte contacts during rulemaking. Now, quick word for my students to give some context here. You may remember that in regular adjudication in the court system, parties are not supposed to have ex parte contacts with the judge or jurors and so forth. So we have ethical rules about this and also procedural rules. So you can't just show up at the judge's house in the middle of the night like they do on that show Suits and ask them to rule in your favor, right? And so we're pretty strict about this. We also have judicial conduct rules about it. And your main takeaway here is that, like hearsay and some of our other procedural protections and fairness protections that we have in the court system, the rules about ex parte contacts are pretty relaxed in the administrative law situation. So we're not saying that there's no such thing, that it's not a valid claim at all, but we are much more tolerant of some de minimis contacts or routine contacts between administrators. And in some ways, this case, the nice thing about this case, even though it's an older case, is that it helps illustrate why, and a little bit gives some insights into how the rulemaking process works. So let's look at what happens in Sierra Club. Again, our main point here is that we have much looser rules about ex parte contacts in administrative rulemaking than we would have in our court system in regular adjudication. And so a successful claim in this regard would probably require something that approaches a bribe or intimidation that substantially changes the final rules. Now, I'm recording this video in January of 2021, in the last few days of President Trump's first term. And there is something to be concerned about here, right? That we've had a number of allegations during the Trump years and maybe in previous administrations as well, but it seemed to be a characteristic of the Trump administration that there were a lot of concerns that the president was directly calling and making demands and trying to incentivize or intimidate lower level civil servants in the executive branch, which is not necessarily supposed to happen, right? Things are supposed to sort of go through a chain of command. And so there have been claims about, and also we right now have a little bit of a scandal of calls between the president and state election officials and state officials about election results. And so this kind of highlights, and whatever your position is politically or from a partisan standpoint, there are concerns in our legal system that the president not have autocratic rule or be able to interfere in normal agency affairs, right? So the president should be setting policy and so forth, but not doing things to reward friends or punish political rivals and so forth. But you should understand that there actually is a lot of latitude here. So ex parte rules are also less strict for agency rulemaking than we would for agency adjudication. And so, in fact, if you really research this area, the cases where we have a concern are usually more like agency adjudication. And the classic scenario is you have multiple parties that are competing for a particular broadcast frequency, let's say, from the FCC, and one of them tries to make friends with or send gifts to one of the commissioners or so forth, hoping that the broadcast frequency will be awarded to them. So when you have multiple parties competing for in a zero-sum game for something like a broadcast frequency, we have a heightened concern that one of those rivals or competitors is going to try to go through back channels to get their way and edge others out. But when we're making a rule that applies sort of to everybody, we're less concerned that, let's say, agency officials are meeting with other elected officials, which is what happened here. Now, this case, Sierra Club v. Costle, was really a multi-pronged challenge to EPA regulations about coal-powered plant emissions. So what's the case overall about? The EPA set emission standards for power plants that use coal, that burn coal. And the conservationist groups thought that the regulations were too lenient. And so this is a really long opinion. If you pull the full opinion off of Lexis or Westlaw, it's 167 pages, not counting dozens and dozens of head notes from the publishers. And so, and now usually there's only a little excerpt in your administrative law casebook. One of the many complaints that were raised by the petitioners was about ex parte contacts during informal rulemaking. And the part of the case that's in administrative law casebooks is typically is an excerpt that's really represents the challenge by the Environmental Defense Fund, or EDF, not the Sierra Club. So the Sierra Club got their name on the caption of the case, but it's really Sierra Club et al. And EDF is one of the et als. And their claim really was focused on these ex parte contacts. And the EDF claimed that there had been a lobbying blitz by the coal industry after the public comment period closed. In other words, the coal industry was concerned that the EPA was going to have strict regulations and that this was going to hurt their profits. And so they started lobbying very aggressively the White House and Congress. And the EDF claimed that this led to the EPA backing away from a stricter standard for coal plant emissions. And here we have the named defendant in the case, EPA Director at the time, Douglas Costle. I've heard his name pronounced a number of different ways over the years, but in his 2019 obituary in the New York Times, they said that it was pronounced to rhyme with hostile, basically, that it's not like castle, it's Costle. So let's move on. He himself is not the key player here. So what had happened was that the EPA officials working on this regulation had circulated a draft rule privately to officials at some other executive branch agencies that are also involved in power plant regulation and pollution control and environmental concerns and safety regulations and so forth, and that somebody leaked this to the coal industry. And so the EDF claimed that 300 comments came in after the close of the notice and comment period, and the EDF claimed that these were mostly from pro-coal sources. The EPA director also had several meetings with the president and White House officials and members of congressional oversight committees. So you might remember that in Congress, there are committees and subcommittees that are assigned to oversee particular areas of public policy, which means that they're going to provide more direct oversight to the agencies that are involved in that branch of policy work than other members of Congress. And so they're likely to kind of have a closer relationship with or have more communication with the officials that are under their subcommittee's purview. So the EDF claimed that all of these post-comment period comments and these meetings with White House officials and congressmen were ex parte communications, and that therefore made the final rule legally invalid. But they didn't really specify which communications were unlawful or why the court should think that they necessarily changed the EPA's rulemaking decisions, right? Remember, the EPA had just closed their notice and comment period. They were circulating a draft for other agencies, among other agencies. And so there could be a lot of reasons that they might have settled on the policy compromise, basically, that they did. And note for students, this is kind of an important one if you're discussing this case in class. The opinion really starts with a special standard of review that's in the relevant statute, the Clean Air Act, for challenges to the EPA's rulemaking. Now, in another part of the course, you are in administrative law. We're going to spend a lot of time on the standards of review under the APA, under the 702 to 706. But sometimes, remember, the enabling statute can sort of supplant or override the Administrative Procedure Act. And the act here said that challenges to rulemaking procedures had to be situations where, quote, the errors were so serious and related to matters of such central relevance to the rule that there's a substantial likelihood that the rule would have been significantly changed if such errors had not been made. Well, that's a pretty high standard, and that's a much more thorough standard than anything we see in the Administrative Procedure Act itself. For those of you who like highlighting things, and remember, every casebook and every edition of every casebook excerpts and edits basically the cases that you have a little differently. But if this quote's in your casebook, this one matters. The court says, the essential message of so rigorous a standard is that Congress was concerned that the EPA's rulemaking not be casually overturned for procedural reasons. And we, of course, must respect that judgment. And this is a great sentence that really captures a lot of the court's discussion in this opinion. And so the DC Circuit ruled in favor of the EPA, the agency, and upheld the rule. Now, some professors and commentators and lawyers find the court's acceptance of the ex parte contacts here remarkable, because Congress itself had hybridized the EPA's rulemaking procedures under the Clean Air Act. And this is discussed in the opinion. What do we mean? Well, the Clean Air Act actually requires that when the EPA makes air pollution regulations, that all the materials like scientific studies and things like that that are submitted, economic studies and industry studies that are submitted before or during or after the the public comment period, that they're put on a public docket so the public can see them. So there's, in other words, there's a special procedural requirement for air pollution regulations under the EPA that gives the more transparency and the public more access to all the materials that are going into the that are informing the EPA's rule, potentially final rule. And this goes way beyond what we would have normally under the Administrative Procedure Act for notice and comment rulemaking. So some take this kind of pro-transparency scheme that's in the Clean Air Act and inferred from that that we should also be extra cautious or concerned about meetings between EPA officials and elected members of the other in the White House or in Congress. But the court disagrees. The court says that hybridized rulemaking did not really change the limited role of judicial review for the informal rulemaking context. And if you look at the date on this case and Vermont Yankee, the Vermont Yankee decision was still in recent memory. And you may also remember that the DC Circuit kind of got smacked down a little bit by the Supreme Court twice by in the Vermont Yankee case. And so the takeaway for the DC Circuit was that they were going to, this panel at least, was going to take the Vermont Yankee kind of deference to agency rulemaking procedures very seriously. And so the docketing requirement means that the agency has an incentive to reveal all its supportive material from any source. So where does this leave us? Well, your takeaway from this case, again, this is where we started. Courts tolerate ex parte communications even after the public comment period closes, when we're talking, at least when we're talking about agency notice and comment rulemaking. Now, remember, in formal rulemaking, the situation might be different because there we have a sort of a closed record. The whole proceedings are on the record with more like trial-like proceedings. But we still have a record that's kind of the file and the documents that go into things with informal rulemaking or notice and comment rulemaking. And we're going to tolerate a certain amount of communication back and forth between executive branch officials, agency leaders, and members of Congress and people in the White House. And so for the courts, this is actually, the idea is it's appropriate, right? For unelected bureaucrats in the federal bureaucracy to receive some oversight from elected officials in the White House and Congress. That's more democratic. Sometimes it can be frustrating when there's somebody we don't like in the White House, or the other party controls Congress, and we wish the agencies could be more autonomous because that's the outcome that we want. But overall, the courts think that it's healthy for the president to have some policy input on the executive branch. And this is kind of a big part of the function of these congressional subcommittees, that they're going to keep tabs and communicate the kind of wishes of Congress to agency officials during the rulemaking process. Also, note that the court's treatment of ex parte contacts involving members of Congress and the White House officials in particular. So what the court does in the opinion here is they start with discussing these comments, public comments that came in after the comment period closed. And part of their end conclusion about that is neither the APA nor the relevant statute forbid consideration of late comments. And so the agency can set a deadline, but there's no real clear rule that that prohibits them from reading late comments that come in late after the deadline. But the court then turns to these meetings with the White House officials and members of Congress, and they have a very hands-off approach there from the standpoint of judicial review, and arguably go even further than the Supreme Court did in Vermont Yankee, like we don't want to touch this. So the court here embraces the idea that rulemaking is partly a political process, right? That we're talking about setting policy for power plants, power plant emissions, and that are going to affect energy prices and coal prices and things like that. And so they're saying that this is not really analogous to cases before the judiciary or the courts. In other words, we're still going to have high standards, strict standards about ex parte contacts with judges and in regular litigation, but policymaking is sort of a whole different animal from the standpoint of governance. The court here concludes that it's lawful and probably appropriate for the president to use informal contacts to persuade an administrator to adopt one of several legally acceptable approaches to implementing a statute. Please note that in Sierra Club versus Costle, the president was not asking the agency to do something illegal or unlawful or to thwart the wording of the statute. The agency was operating within its discretion, and other sections of this very, very long opinion are actually addressed to whether the merits of the rule itself, whether the agency's rule about coal plant emissions fulfills the statutory mandate or is arbitrary and capricious and so forth. But assuming that it's otherwise legal, the president can express preferences to the agencies. That's part of what being the head of the executive branch involves. Okay, here's a second quote, from the opinion that I pulled out that I think is really great or illuminating. We do not believe that Congress intended the courts to convert informal rulemaking into a rarefied technocratic process, unaffected by political considerations or the presence of presidential power. And this nicely kind of summarizes the discussion in this opinion and later opinions about these concerns with ex parte contacts, is that they don't think Congress intends to have the agency operating in isolation. Okay, here's a quick review question to see if you've been paying attention. May an agency director talk to the president or members of congressional oversight committees about pending regulations even after the public comment period ends? Yes or no? This was supposed to be an easy question, and if you're not really sure, you should probably rewind and rewatch this video. And that concludes our discussion about Sierra Club v. Costle.